All rise. Vous vous levez.
Welcome, everyone. Thank you for joining us. We are Alessandra,
Maira,
Brianna,
and Adriana.
And we are students in human rights and humanitarianism at the Geneva Graduate Institute.
Today, we will be discussing how human rights fact-finding missions and human rights information documented by NGOs can interact with the international criminal justice system.
So where to begin? A situation of serious human rights violations has occurred, one that involves the mass loss of life, torture, sexual violence, or crimes against humanity.
TRIAL International is a Geneva-based NGO fighting impunity for international crimes and supporting victims in their quest for justice. They work in the field with local NGOs facing these exact situations. We are glad to have a representative from TRIAL joining us for today's discussion.
Ms. Chiara Gabriele, a senior legal advisor for the Great Lakes program at TRIAL, shares with us a situation in the Democratic Republic of Congo, the DRC.
2012 in South Kivu, so in this region in the east of the DRC, there were two massacres in two villages, one after the other, the villages of Kamananga and Lumenge. The massacres were carried out by members of the Force Démocratique de Libération du Rwanda, the FDLR. And basically what happened was that there were a number of people that were murdered, a number of people that were tortured, and also cases of arson and pillaging.
Now, it's of the utmost importance to find justice and accountability for the sake of the victims involved.
And one of the ways accountability can be met is through the international criminal justice system, which can prosecute individuals under international criminal law in either national courts or the International Criminal Court, the ICC.
But wait, what types of crimes are prosecuted by international criminal law?
Well, under the Rome Statute, there are 4 types of crimes that fall under ICC jurisdiction. These are genocide, crimes against humanity, war crimes, and crimes of aggression. So, what is the criminal justice system to do? How did they begin to find evidence? How can human rights information help?
Well, one option that we're exploring in this podcast is the use of human rights fact-finding information. According to the Raoul Wallenberg Institute, fact-finding means a mission or visit mandated by an NGO or one of the UN bodies to ascertain the relevant facts that relate to and shed light on a situation of human rights concern.
Taking into consideration his expertise, we would like to introduce our second inspiration for today's discussion, Professor Lyal S. Sunga.
Professor Sunga is an expert in international humanitarian, criminal, and human rights law. He's an affiliated professor at the Raoul Wallenberg Institute of Human Rights and Humanitarian Law in Lund, Sweden. He's also a former senior human rights officer for the UN Office of the High Commissioner for Human Rights in Geneva.
We've asked Professor Sunga, what is the criminal justice system to do? How do they begin to find evidence? And he shed some light on the difficulties of the process, especially focusing on the ICC.
The ICC doesn't have a pile of investigators to go everywhere around the world. They are reading the newspapers, they're reading UN reports, and these are all human rights reports. They're going to get a lot of information from NGOs. The ICC is the last, often, if they go ever, to arrive. The Human Rights Council missions and under special procedures, investigative missions, commissions of experts, etc., can act as a precursor to trigger either the establishment of the tribunals, for example, Rwanda, Yugoslavia, or these days to encourage the ICC prosecutor to take things up.
Here, the professor has introduced the importance of NGOs, UN fact-finding missions, and its reports in the decision of the ICC to take on a case and the gathering of evidence. Ms. Gabriele gives an example of how the work of local human rights NGOs contributed to bringing the DRC case into the courtroom.
An NGO, like a local NGO, at the time, right after the commission of the crime, managed to access the crime scene, and they took some pictures with their phone of the crime scenes. Those pictures were all considered admissible, and they were all used in order to prove the context of crimes against humanity, because there was a massive attack against the civilian population. They were also used to prove specific crimes, for instance, the acts of torture, or because of the picture of the crime scene, also the massacre and the arson, because a part of the village was put in fire, basically.
Ms. Gabriele also illustrates how NGOs are imperative to accessing scenes where violations have occurred, because of the important relationship they have with the victims.
It might be easier for victims of survivors to trust people that they might have a feeling, understand them in a way. Just to be there and talk to them was for them a recognition in itself that what they suffered mattered. And finally, it's a matter of language, which is also extremely important because some of the victims and witnesses speak a specific form of some languages, and even finding interpreters and reliable interpreters might be challenging. And there is also a matter of trust.
So how do these actors find facts on human rights violations and produce their reports? Professor Sunga expands further.
You want to talk to NGOs, you want to talk to the International Committee of the Red Cross if it's a humanitarian disaster. And you also want to talk to the UN agency heads. So it's going to be UNDP, UNHCR. That's why NGOs are so valuable, because they haven't just dropped in out of nowhere. I mean, I'm not saying Geneva's nowhere. So it means that, a lot of these NGOs, they have been there for maybe decades. They have contacts, they know things, and they're the first on the scene, local NGOs. Then you have regional, of course, and international NGOs, which may show up later or much, much later. Also, these international NGOs, take Amnesty International, they have long developed contacts locally. That's how they operate as well, from the ground up. So NGOs are absolutely essential, and that's why it's very important for human rights fact-finding. I would say that UN human rights fact-finding wouldn't be anything without NGOs. I mean, it would be so weak and brittle and thin and superficial, it wouldn't be worth very much.
Now that we have established that the UN works alongside NGOs to make their official human rights reports, let's look at how the criminal justice system uses NGOs and fact-finding reports and why they are so essential in court.
Human rights information is really very, very useful, and it can't be ignored. It's all around, and that's what mostly you're getting before you get anywhere near notions of individual criminal responsibility, because you have to see that there are violations first, right? And those violations and notice of violations come out from human rights monitoring, from the activities and complaints of NGOs. All that is infused already in terms of the information space. Human rights information is usually important in terms of background, context, command structure, maybe about the military, state of the judiciary, independence of the judiciary. That's important for Article 17 of the Rome Statutes. The court, the ICC, is not even going to have jurisdiction if the national courts are going to prosecute. I mean, the prosecutor is going to prosecute and the court's going to take it, right? Because it's a complementary jurisdictional situation. So how do you assess that? Human rights people do that. There's a special rapporteur on the independence of the judiciary. There's the Universal Periodic Review. There are special procedures relating in other ways to independence of judges and lawyers, etc. So all that stuff is human rights stuff. As if the ICC has time and resources to do that. They don't.
This is why understanding patterns of human rights violations is absolutely necessary to establishing probable cause. And who identifies these patterns? Human rights information. We can see this in the example of fact-finding in Rwanda, where Professor Sunga worked as a human rights officer.
I mean, real clear patterns. When we were in Rwanda, we examined, took a look at the bodies, and you could see that the cards, their ID cards, said Tutsi on it. And, with the picture of the person that's been killed. So it's like, okay, so the Tutsis are the victims, and also the sign, on their house was written Tutsi. So it was premeditated. They were marked out first as Tutsis and then they were massacred. So things like that. I mean, we noticed those things and we would say that, look, this is looks like intention to wipe out in whole or in part national, ethnic, racial, or religious group as such, to quote the Genocide Convention, because you have this clear motive. And this was part of my work, that I was there with the Commission of Experts to support their work. There were 3 commissioners. And what we found is that this was very clear, premeditated, planned, systematic. So for us, the connection wasn't very mysterious between the responsibility of the state, if you like, and the criminal responsibility of the individuals in government and the actual low-level perpetrators. And this is where commissions of inquiry, which we haven't really mentioned so far, but this is where they are so key, or commissions of experts. And that's why it was a big eye-opener for me when I was involved in that, because that is in between human rights in a way, and looking for patterns of serious human rights violations that look like crimes under international law.
But does this always work so smoothly together? What are the potential risks in this interplay between human rights fact-finding reports and their application under international criminal law?
The risk that UN human rights fact-finders themselves see themselves as criminal investigators, which they're not, unless they are mandated by the Human Rights Council or by the Security Council or by possibly the General Assembly to carry out that type of investigation. So therefore you shouldn't overstep your bounds on either side. And, the ICC shouldn't overstep its bounds. It shouldn't start making big pronouncements about human rights or about political matters or anything like that. And it knows that. They know that. And neither should commissions of inquiry or of experts and human rights fact-finders start saying that these people in government are shameful because they are guilty of this and that, right? You just don't see that because people are in this field pretty cognizant of this difference and the different rules. We can start pointing fingers, and we don't have a power to lay an indictment, and we can't even necessarily directly refer to the prosecutor information, but we could gather it, we could organize it, and then we could officially send it there. So, if you're in the field and you're there and you find information's coming, everybody's saying it was this person. We saw them, we know them, he's from our neighborhood. I think you have to take that information down, but you're not in a position to go say, oh, we're going to prosecute. You don't have a mandate to do that normally. What you can do is say this person should be prosecuted. What you can do is go to the Human Rights Council and say, you know what, we have very clear evidence of crimes under international law being committed. And we even have a confidential list of perpetrators. Even in Rwanda, we assembled a confidential list of perpetrators. So that's been done for a long time. Now, if you're mandated to go look into violations of Common Article 3 and, Protocol 2, and to look into crimes against humanity and stuff like that, you should point it out. In fact, the Commission of Experts on Rwanda was mandated in that sense, not to prosecute, but to gather information, and then that could be useful for prosecution. Same with Yugoslavia. So again, I think the UN, Security Council and Commission on Human Rights, and now it's called the Human Rights Council, have been very cognizant that serious human rights violations constitute crimes under international law, and that human rights investigators are there, fact finders are there, and that information shouldn't be lost. And it could be useful either in the background or even with regard to specific persons.
Ms. Gabriele adds to this by expressing the importance of understanding standards when collecting human rights information, as well as the limits of gathering evidence by too many organizations.
The NGOs doing monitoring and submitting reports to the prosecutor. This is very, very important because of course this might push the prosecutor to open an investigation. But once that investigation is open, the type of evidence that have to be submitted have to be to a certain standard. So I see the risk when you do an investigative mission, but the purpose changes over time. So it's important that you know where your information is going. If you document specifically for a criminal procedure, then the standard is different. If you document to, for instance, write a report, and then all of a sudden that information needs to be used in a criminal procedure, there I see a risk. Because the standard with which you documented was not the same. And so there might be risk also in terms, for instance, of security and protection for the victim, of consent, etc. And one other limit that I think it's quite important to mention is a matter, for instance, of coordination. What has been happening right now is that you have, if you see the situation in Ukraine, you have a lot of different NGOs documenting at the same time. And this might be a problem because of re-victimization. So if a victim is supposed to give the same statements multiple times, is of course an issue of harm. So it is in violation of the principle of do no harm. The other problem is that because there might be minor inconsistencies among the different versions, this might actually be used afterwards in order to challenge the reliability of the witness statement in itself. So this is another issue and another limit that I think it's important to mention. Mm-hmm. So of course, some of the information gathering and the type of evidence can afterwards be filed in court in specific jurisdiction when it is possible to do so through the lawyers representing the victims. And I think NGOs have a role to play in that. But this doesn't mean that the prosecution has to be hampered in any ways, and there are indeed some limits that need to be respected.
So what comes next? What are the possibilities of these two systems working together? Professor Sunga is incredibly optimistic at the prospect of human rights fact-finding and its effectiveness in international criminal law.
International criminal law has invigorated international humanitarian law in an amazing way. Because everybody now wants to know what are the laws of war and what does it mean to violate them. And human rights is heavily infused there. So it's given a hard edge to human rights law that just didn't exist before in that same way at all. And so that's given a lot of credibility to it. So it's been mutually strengthening in such a powerful way that I'm just very, very optimistic. For a long time, the ICRC, for example, continued to work in IHL, Geneva Conventions, protocols, etc. The human rights folks kept on doing just human rights stuff in a big way, in a big picture, etc. And this was kind of frustrating to me because my focus since before I started at the UN was the interplay between all these. And then there's international criminal law, which is overlapping between it's serious human rights violations and violations of humanitarian law. So I'm gratified to see that people these days are studying and learning about your generation, about international humanitarian law, human rights, and international criminal law. So it's never done before. So I think that there's a lot of room for what I would say is a symbiotic relationship and mutual interdependence. And believe me, there's a lot of work for everyone.
Likewise, Ms. Gabriele and Trial International would like to emphasize the importance of prioritizing the use of national courts over the ICC in bringing accountability to perpetrators of human rights violations, as she describes further.
You have different ways of prosecuting international crimes, and we do believe that the primary responsibility to prosecute international crimes should be on the territorial state. So in the state where crimes have been committed. Why? Because once again, it's a matter of accessibility of the evidence. So the possibility of, for instance, going to the crime scene, collecting a different type of evidence, etc. But it's also a matter of getting justice closer to survivors in a way. It's important to have those trials as close as possible to the place in which crimes have been committed. So this is also a part, in a way, of reparation.
During this podcast, our interviewees have guided us through a complex path on how fact-finding and human rights information is used, can be used, or even whether or not it should be used for international criminal prosecution.
We also heard about how different actors, the UN and NGOs mainly, engage with these activities, their strengths and shortcomings.
So what are the main takeaways from this dialogue?
First, not only lawyers, judges, victims, or perpetrators inhabit the international criminal law scene. NGOs and local actors are also active participants. Since the adoption of the ICC Rome Statute in 1998 and its coming into force in 2002, the criminal justice system has come a long way.
Today, human rights monitoring and fact-finding actors are relevant characters that foster how a crime is prosecuted, how the event is framed, which facts are seen as important, what language is used, or even how the law is mobilized. This illustrates how the push for accountability in the global setting has different origins and sources that for some might even collide.
Second, international criminal justice deals not only with the legal apparatus of justice, but also with the political, affective, and social practices of what justice means. From human rights culture to the knowledge and inner workings of NGOs and the UN, we find a patchwork of justice-making practices that include feelings, contestations, and imaginaries that are made and remade in different contexts.
Third, when fact-finding information interacts with the criminal justice system, some challenges may arise. As the thin line between law and politics begins to disperse, credibility and legitimacy can be contested, and bounds might be overstepped.
All of this being said, some questions still remain regarding human rights information.
It might be difficult to reach a common goal of accountability when dealing with the differences between human rights information gathering and criminal law. For instance, the Human Rights Directive of reasonable grounds to believe and the ICC's different burden of proof of beyond reasonable doubt are in conflict. Mixing the two might contest their nature.
However, as we can see from the podcast, both human rights information and the criminal justice system work to bring accountability to those responsible for human suffering in the name of humanity. Professor Michael Barnett, an expert of international relations, invites us to see human rights and humanitarianism as practices that are rooted in this common concern for alleviating human and social suffering, which he calls practices of humanity.
Having listened to our interviewees' considerations on the subject, can we bring international criminal law into this framework of practices of humanity? This might be possible due to the fact that international criminal law emphasizes punitive justice in order to defend humanity, with a focus on crimes of mass atrocities and on finding the responsible individuals in the name of humanity.
Ultimately, we must also remember it is important to reiterate the NGO's mantra in international criminal justice advocacy. Justice must not only be done, but must also be seen to be done. Perhaps human rights information might help in that regard.